At today's Senate Armed Services Committee hearing on sexual assaults in the military, Arizona Senator Martha McSally said she was raped by a superior officer while serving as a fighter pilot in the Air Force. She talked about failures in how the military investigates sexual assaults and mistreatment of survivors.
So, like you, I am also a military sexual assault survivor. But unlike so many brave survivors, I didn't report being sexually assaulted. Like so many women and men, I didn't trust the system at the time. I blamed myself. I was ashamed and confused. And I thought I was strong, but felt powerless. The perpetrators abused their position of power in profound ways. And in one case, I was preyed upon and then raped by a superior officer. I stayed silent for many years, but later in my career, as the military grappled with scandals and their wholly inadequate responses, I felt the need to let some people know I too was a survivor. I was horrified at how my attempt to share generally my experiences were handled. I almost separated from the Air Force at 18 years over my despair. Like many victims, I felt the system was raping me all over again. But I didn't quit. I decided to stay and continue to serve and fight and lead, to be a voice from within the ranks for women, and then in the House, and now in the Senate. So this is personal for me too, but it's personal from two perspectives: as a commander who led my airmen into combat and as a survivor of rape and betrayal. I share the disgust of the failures of the military system and many commanders who failed in their responsibilities. But it's for this very reason that we must demand that commanders stay at the center of the solution and live up to the moral and legal responsibilities that come with being a commander. We must fix those distortions in the culture of our military that permit sexual harm towards women and, yes, some men as well. We must educate, select, and then further educate commanders who want to do the right thing, but who are naive to the realities of sexual assault. We must ensure that all commanders are trained and empowered to take legal action, prosecute fairly, and rid perpetrators from our ranks. And if the commander is the problem or fails in his or her duties, they must be removed and held harshly accountable.
We'll show you now the full Senate Armed Services Committee hearing, including testimony from two women who were sexually assaulted while serving in the military. Senator Thom Tillis chairs this 2-hour, 15-minute hearing.
Committee come to order. I understand Senator Gillibrand will be here briefly. She's in the building, and I think that will give me time to make a few brief opening comments. I want to thank everyone for being here today. We meet this afternoon to receive testimony on sexual assault prevention and response programs and policies in military services. On panel one, we will hear from 5 witnesses. Colonel Don Christensen, U.S. Air Force, retired and now Director of Protect Our Defenders. Welcome. Dr. Ellen Herring, U.S. Army, retired and now CEO of the Service Women's Action Network. Welcome. Lieutenant Commander Aaron Lee Elliott, U.S. Navy. Miss Angela Bapp, formerly an officer in the U.S. Army. And Colonel Doug James, U.S. Air Force, retired and now President of Save Our Heroes. Thank you all for coming here. I'll introduce the second panel when we transition into their testimony. The Personnel Subcommittee exercises rigorous oversight of DOD sexual assault prevention and response policies and programs. And over the past 10 years, the committee has spearheaded the enactment of hundreds of legislative changes that have affected every aspect of the military sexual assault prevention and response program. These provisions of law include protect and empowering victims, reforming the military justice process, holding offenders accountable while protecting their due process rights, and ensuring command accountability for the investigation, prosecution, and disposition of allegations of sexual misconduct and retaliation. I feel confident when I say sexual assault prevention and response policies and programs in the armed forces are the most comprehensive and the most aggressive in the United States and perhaps the world. I credit Ranking Member Gillibrand with shining a spotlight on these important issues, and I applaud her persistence for focusing on the subcommittee's actions. I've been in the Senate for 4 years, and she's been a consistent standard bearer for the issue, and I compliment the ranking member. I'm glad you're here for me to compliment you directly, ranking member. But the subcommittee knows that sexual assault, unwanted sexual contact, sexual harassment, and retaliation are issues that affect not only the armed forces, but our society as a whole. We expect our armed forces, however, to be better. We expect the military to lead the way in fixing these issues. We expect our military to set the example for the rest of society to follow. The purpose of this hearing today is to help our military do just that. Much has been accomplished, but there remains much more to be done. I will turn to Ranking Member Gillibrand at this time, followed by recognition of Senator McSally. Senator Gillibrand.
Thank you, Chairman Tillis, for holding this hearing. I'm very grateful, and I'm really grateful to our witnesses today. Thank you so much for being here. I'm pleased that our subcommittee is committed to solving our military sexual assault problem, but I have to say that I'm incredibly disappointed that after years of fighting this problem, after so many incremental changes in the law, that we are still in the exact same place. Sexual assault in the military is still pervasive. It's still hurting our military readiness. It's still causing thousands of our service members to suffer. The trends and numbers are going in the wrong direction, so we must fix this. We need a fundamentally different approach to how these crimes are being prosecuted because the services have not done nearly enough to solve the problem themselves. My office routinely receives information from a variety of sources about the military's failure to appropriately address sexual assaults and other sexual misconduct. I'm counting on our witnesses on the first panel to describe the problems encountered day to day by survivors of sexual misconduct, and I want to note my appreciation of the survivors willing to testify. They have served our country and now are leading additional service by having the resolve to share their painful experiences with us and with the world. Witnesses on the second panel should listen carefully to the testimony of the witnesses on the first panel, as I expect the second panel witnesses to address the issues described by the first panel. It should be clear to any unbiased observer that the military is not attacking the problem with any of the focus or intensity that it would attack just about any other problem. The Department of Defense consistently tells us that addressing sexual assault in the military is a chain of command responsibility and that the chain of command will fix it. But the chain of command has failed in this regard. The most recent survey of prevalence of unwanted sexual conduct found that sexual assaults have increased at the military service academies, and other surveys by the department itself show that while increased reporting of cases, let me say it again. Other surveys by the department itself show increased reporting while cases are decreasing and a very alarming rate of retaliation by those in command against victims of sexual assault. The Pentagon's next annual report on sexual assault in the military will include the results of the most recent survey of military personnel across the department. It won't be surprising, but I'll be disappointed, though, to see a similar increase in unwanted sexual contact throughout the services. One of the main causes of this problem is that despite many good leaders, far too many commanders do not make it a priority to address the problem of sexual assault in the military in a meaningful way. I recently reviewed a military investigation about how the chain of command addressed sexual assault at a major command. The commanding general did not even attend case management group meetings where sexual assault cases were discussed in detail as required by the DoD and service regulations. A brigade sexual assault response coordinator position was left vacant for 9 months. Professional training of officials involved in sexual assault was conducted on an ad hoc basis and not documented in training records. Sexual assault professionals used obsolete forms to inform sexual assault survivors of their rights and options. Survivors were not informed of one of the most important rights, the right to representation by Special Victims Counsel. This command had undergone an earlier inspection that identified these and many other shortfalls in the command sexual assault prevention and response program, yet as far as we know, no one was held accountable for these continuing failures. If this is how the chain of command operates to address sexual assaults in the military, it's clear why we're not succeeding. All too often, we hear from survivors that they are the ones who are punished when they report sexual assaults. We hear from survivors that they are retaliated against, sometimes by the chain of command, sometimes by their peers. In either case, the chain of command must put a stop to it. In too many cases, survivors are punished for collateral misconduct, such as underage drinking or fraternization, while the assailant who committed sexual assault goes free. This happens even when the only reason that commanders know about this collateral misconduct is because the survivor reported that he or she was assaulted. It's no wonder that survivors are reluctant to report. So I continue to believe that a fundamental reform is warranted in our military justice system. That is how we finally protect our service members from these crimes, and it's how we'll strengthen our military. Mr. Chairman, I'm committed to working with you on this issue, and I hope that we can use what we learned today to help solve this problem once and for all.
Thank you, Senator Gillibrand. Senator McSally.
Well, thank you, Chairman Tillis. I also want to thank Senator Gillibrand for her advocacy for women in uniform and her passion for stopping the crime of sexual assault in the military. This is also a passion of mine for many reasons, and I think I bring a unique and important perspective. My drive to fight against sexual assault in the ranks is not from the outside looking in, and it is deeply personal. First, for 2 years, I was honored to be a fighter squadron commander in the United States Air Force. Command is the most impactful duty one can have directly on the lives of servicemen and women and their families. I was greatly privileged to prepare and then lead my amazing airmen in combat, which is the apex responsibility of any warrior leader. Military commanders are placed in a position of authority and responsibility like none in civilian life. They are not like CEOs or managers or any other supervisor. Commanders have a moral responsibility to ensure readiness of their units, which, yes, includes warfighting skills, but demands that the commander cultivates and protects and enriches a culture of teamwork, respect, and honor. Conduct, any conduct that degrades this readiness doesn't just harm individuals in the ranks, it harms the mission and places at risk the security of our country. Commanders also have a covenant with the men and women under their command, the 1% who volunteer to serve in uniform. They're asked to follow lawful orders that could risk their lives for the mission. In return, it's the commander's responsibility to surround their people with a climate of integrity, discipline, and excellence. During my 26 years in uniform, I witnessed so many weaknesses in the processes involving sexual assault prevention, investigation, and adjudication. It motivated me to make recommendations to Air Force leaders. It shaped my approach to command as a commander, and it informed my advocacy for change while I remain in the military and since I've been in Congress. We've come a long way to stop military sexual assault, but we still have a long way to go. When I first entered the Air Force Academy in the 9th class with women, sexual harassment and assault were prevalent, but victims mostly suffered in silence. It took too many years and too many lives ruined. But thanks to the bravery of some survivors like those on our first panel today, significant change has happened. I am so inspired by the many survivors who found the strength to share their stories, report their assaults, and demand accountability, justice, and change. It's because of you that a light has been shined on this silent epidemic, and so many improvements have been made, including more than 100 legislative actions over the last decade on all aspects of military sexual assault. So, like you, I am also a military sexual assault survivor. But unlike so many brave survivors, I didn't report being sexually assaulted. Like so many women and men, I didn't trust the system at the time. I blamed myself. I was ashamed and confused. And I thought I was strong, but felt powerless. The perpetrators abused their position of power in profound ways. And in one case, I was preyed upon and then raped by a superior officer. I stayed silent for many years, but later in my career, As the military grappled with scandals and their wholly inadequate responses, I felt the need to let some people know I, too, was a survivor. I was horrified at how my attempt to share generally my experiences were handled. I almost separated from the Air Force at 18 years over my despair. Like many victims, I felt the system was raping me all over again. But I didn't quit. I decided to stay and continue to serve and fight and lead, to be a voice from within the ranks for women, and then in the House, and now in the Senate. So this is personal for me too, but it's personal from two perspectives: as a commander who led my airmen into combat and as a survivor of rape and betrayal. I share the disgust of the failures of the military system and many commanders who failed in their responsibilities. But it's for this very reason that we must demand that commanders stay at the center of the solution and live up to the moral and legal responsibilities that come with being a commander. We must fix those distortions in the culture of our military that permit sexual harm towards women and, yes, some men as well. We must educate, select, and then further educate commanders who want to do the right thing, but who are naive to the realities of sexual assault. We must ensure that all commanders are trained and empowered to take legal action, prosecute fairly, and rid perpetrators from our ranks. And if the commander is the problem or fails in his or her duties, they must be removed and held harshly accountable. I don't take this position lightly. It's been framed often that some people are advocating for the victims, while others are advocating for the command chain or the military establishment. This is clearly a false choice. There are many commanders who would welcome taking this responsibility off their plate. Those are the very commanders we don't want leading our troops. We cannot command change from the outside alone. It must be deployed from within. It must be built and constantly maintained and expertly managed by commanders who are themselves educated, conditioned, and given the tools to ensure what you survived and what I survived happens to no warrior under their command. To that end, I very strongly believe that the commander must not be removed from the decision-making responsibility of preventing, detecting, and prosecuting military sexual assault. We are survivors together, and I'm honored to be here and use my voice and unique experience to work on this mission and stop military sexual assault for good. Thank you, Mr. Chairman.
Thank you, Senator McSally. Any other members wishing to make comments before we hear from the witnesses? If not, Colonel Christensen, welcome.
Chairman Tillis, Ranking Member Gillibrand, and members of the subcommittee, thank you for the opportunity to appear before you and for your interest in the military justice system. And Senator McSally, thank you for those amazing words. We don't see eye to eye on the solution, but sharing that was very, very powerful. As a brief introduction, I retired after 23 years of service as an Air Force JAG. And during this time, I focused my career on practicing military justice. I have served twice as a defense counsel, multiple times as a prosecutor, including as the chief prosecutor of Europe and Southwest Asia, and as the chief prosecutor for the Air Force, and I also served as a military judge. For the last 4 years, I have served as president of Protect Our Defenders, a human rights organization dedicated to ending sexual assault in the military. The scourge of sexual assault in the military has rightfully brought great scrutiny on the military justice system and the role of the chain of command. The prevalence estimates over the last decade have vacillated from a high of 26,000 to a low of 15,000. But one thing must be recognized. When it comes to the prevalence rate of sexual assault against women, it is unchanged for the last decade. In 2010, 4.4% of women were sexually assaulted in a year. In 2016, the most recent numbers we have, it was 4.3%. In other words, the women service members, there has been no real improvement despite decades of promises from leadership and claims that commanders are the solution. To compound this failure to drive down the prevalence rate, the commander-controlled system has failed to deliver accountability. Despite fiscal year 17 having seen unrestricted reports of sexual assault skyrocket to an all-time high of 5,111, actual prosecution rates plummeted to 7.9%. Moreover, the military failed to achieve a conviction for a sex offense in 60% of the cases they took to trial. And that's a very few number of cases, about 400. As a result, only 166 offenders, or about 3% of the 5,111 reports, resulted in a conviction for a non-consensual sex offense. Put another way, 99% of the estimated 15,000 victims never saw justice in their case. To make matters worse, 60% of survivors who report openly suffer retaliation that is often career-ending. In 2016, the DODIG found that 1/3 of women who report are out of the military within 1 year of reporting, typically within 7 months. And their discharge characterization is much lower than the general military population, denying them benefits such as the GI Bill. One way to look at this is a woman is 12 times more likely to suffer retaliation than she is to see her perpetrator held to account. No one can look at these numbers and call this success. We have heard for decades from military leadership how they're going to fix things and how they have zero tolerance. But these statements have proven empty. At the same time, military leadership has pushed back on any effort to modernize the military justice system by giving military prosecutors the authority to make prosecution decisions rather than the very small number of commanders who now have that authority. It is time to accept that making prosecution decisions for serious crimes such as rape, murder, sexual assault, child sex abuse, child pornography possession, among many other serious crimes, are best done by attorneys with significant experience in courtroom trying such cases. I often hear opponents of reform say we trust commanders to lead our sons and daughters in combat, so why shouldn't we trust them to make prosecution authority? The answer is simple. We trust them to lead in combat because they are members of the profession of arms. By training and experience, they're qualified to make those decisions. However, there is nothing inherent to being a commander that qualifies someone to make prosecution decisions, as the current practice is in the military. We must accept that the profession of law is best suited to make legal decisions, just like the medical profession is best suited to make medical decisions. We would never accept a commander telling a doctor how and when to make life-saving medical decisions. Similarly, we should stop assuming commanders are qualified to make legal decisions. Removing prosecution decisions for serious crimes from around the 400 commanders who currently have general court-martial convening authority would in no way diminish the authority of the remaining 14,000 commanders in the DoD. These commanders would still have all the same authority that they currently have. Authority to order suspects in a pretrial restraint, to issue no contact orders, to ensure both the victim and the accused have access to services and legal representation, to approve expedited transfers, to administratively discharge people. All those authorities remain. It is a false narrative that commanders would no longer have a vested interest in taking care of victims. Instead, removing prosecution authority would empower commanders to be more vocal on the issue of reducing the risk, by reducing the risk that their comments would be viewed as unlawful command influence. The ABA has long recognized that prosecution decisions should be made by licensed attorneys subject to ethical standards. That is not a radical concept, and it's past time for this standard to be in the military. We should hold our ideal, whether in the military and the civilian society, that we prosecute those who commit crimes when the evidence is legally sufficient. We should never prosecute someone when the evidence fails to meet that legal standard, and we should absolutely never prosecute to send a message when the evidence to prove guilt is lacking. The persons best suited to make that call are independent prosecutors. I thank you and look forward to your questions.
Thank you, Colonel. Dr. Herring.
Thank you. I'm Ellen.
I should mention that we do have the time limit. You did very well staying within it, but we want to make sure we can get to the questions. If you'll be mindful of the time on the monitor. Thank you.
Mine will be even shorter, so save a little time there. I'm Ellen Herring, the CEO of the Service Women's Action Network. I retired from the Army in 2014 after 30 years of military service. I'm a West Point graduate, and I have a master's degree in public policy and a PhD in conflict analysis and resolution from George Mason University. I've taught at the Army's Command and General Staff College, the Army War College, and at Georgetown University, and my academic research and work focus on women and gender in the military. I commanded Army units, like yourself, at multiple levels. During my very first Army assignment overseas, one of my soldiers was murdered, and I closely watched as the criminal investigation and subsequent conviction unfolded. Years later, in 1998, when I was a major stationed in Hawaii, I was assigned as the investigating officer in 3 rape cases. The perpetrator, an NCO, was eventually reassigned to another unit. I juxtaposed these 2 experiences to illustrate the very different ways the military has approached how felony crimes are handled. Fortunately, and to the credit of Senator Gillibrand and others, the Army is no longer allowed to assign an untrained officer to investigate cases of rape. Now, criminal investigators are responsible for such investigation, but commanders remain in the decision-making process. The Service Women's Action Network is a nonpartisan, nonprofit organization dedicated to supporting, connecting, and advocating for service women past, present, and future. SWAN was established in 2007 by a group of women veterans who were having trouble getting their VA claims approved. The VA did not recognize sexual assault as a potential source of post-traumatic stress, the way it recognized combat stress. SWAN decided that they needed to spotlight the problem of military sexual assault in order to get the post-traumatic stress that results from it recognized by the VA. SWAN spent the next decade making military sexual assault visible in and outside of the military. We have worked with law and policy makers, Senator Gillibrand in particular, to change the UCMJ to better support victims of military sexual assault, to hold perpetrators accountable, and to have the post-traumatic stress that results from a sexual assault recognized by the VA. SWAN continues to work with victims, connecting them to resources and advocating on their behalf. SWAN supports the Military Justice Improvement Act because it removes untrained commanders from deciding if, when, and how to move forward in felony cases. Additionally, it eliminates commanders' ability to overturn convictions or to reduce punishments. The UCMJ is a living document, and it has repeatedly changed over the years, often in response to or an acknowledgement of its shortcomings. This is one of its shortcomings, and SWAN fully backs a change in the military UCMJ at this time. I look forward to your questions.
Thank you. Commander Elliott.
Good afternoon, Senators, and thank you for inviting me here today. I appreciate the opportunity to speak about my experiences and share my thoughts. I've been in the Navy for a little more than 14 years, have served on 6 different ships, and lived around the country and the world. In August of 2014, someone who I had considered a close friend raped me. It was an extremely traumatic experience, one that nearly destroyed me. Initially, I made a restricted report. I did not want my commanding officer to know, nor did I want law enforcement involved. I spent months in shock, and the only way I made it through this was with the support of my good friends and the SAPR team. As I progressed in my healing, starting to work through the PTSD, anxiety, and depression I was diagnosed with due to the assault, I moved to a new command with a new commanding officer. I began considering changing my report at this point from restricted to unrestricted. I was very lucky at my new command. I had a wonderful commanding officer and a great work environment. When I decided to change my report to unrestricted, I had this amazing support from this commanding officer, someone I consider the best leader I've ever known. He went above and beyond what was required of him in this situation. Unfortunately, I would learn through my experience and through other victims' experiences that this support team is not the norm. While I did not expect everyone to be the great leader he was, I did expect to be treated with the same dignity and respect he showed me, and I was not. When I moved to my new duty station overseas to be a commanding officer of a warship myself, It was made immediately apparent to me that the fact I was a sexual assault survivor was a burden and inconvenience to my bosses, and the upcoming court-martial for the person who raped me was just a hindrance to them. Due to the appeals regarding a decision the presiding judge in the case had made when I reported to the new command, it was unknown when the court-martial would happen. One of the first things my new boss said to me regarding the court-martial was, well, I hope it's not during an important part of the ship's life, which all I could think was, well, next time I get raped, I'll try to plan it better. This was the first of multiple comments that my bosses said to me that not only re-victimized me and were extremely insensitive, but made me seriously question continuing to move forward with the case. One of the most degrading and humiliating experiences was when my boss was forwarded a copy of the NCIS report that discussed intimate details of the assault. I was called into his office where he told me he had received and read the report. After he handed me the report, I read it. I very seriously considered dropping the case as I did not want my boss reading about my vagina. And when I left my ship for a few weeks to be at the court-martial, my boss told me how he had to temporarily leave someone in command for several months because they had cancer and needed to get treatment. He told me that he would much rather go through what I went through than have cancer. I can tell you, after being diagnosed and treated for breast cancer last year, I would much rather go through that than the assault. Upon returning from the court-martial, nothing within the command environment got better. I was humiliated, ostracized, outcast, and ridiculed from people of every rank. There were multiple events for commanding officers that I was not invited to attend. My ship was given unfair scrutiny, magnitudes greater than what any other ship saw. And what nearly broke me, and what almost was as bad as the assault itself, my personal information regarding the assault was divulged to my peers, including counseling information I'd only discussed with my bosses, who then used it to humiliate and demoralize me. If I could have gotten out of the Navy at that point, I would have, but I was in a contract. As commanding officers in the Navy, we were given a 3-day legal course in preparation for our tours. I'm by no means a legal expert, was equipped to deal with the minor infractions that affect good order and discipline. It is my belief, not just as a military sexual assault survivor, but as a former commanding officer, that some infractions are so grievous, so heinous, that they must be elevated to a higher level than just command. The command level. Sending sexual assault cases to trained military judges shows how serious this crime is taken, that we will not allow perpetrators to get away in this crime, and it reinforces to countless victims that they will be taken seriously. Thank you for your time, Senators, for allowing me to share a small piece of my story with you.
Thank you, Commander Elliott. Ms. Bapp.
Chairman Tillis, Ranking Member Gillibrand, and members of the subcommittee, thank you for this opportunity to speak to you as a survivor of military sexual assault. I'm here to share my story and to shine light on the systemic failures that made justice impossible in my case. I graduated in the top 3% of my class at West Point, and soon after arrived at Fort Rucker, Alabama to begin my career as an aviation officer. Throughout flight training, I grew to become close friends with a mentor and flight school classmate of mine who was going through a divorce. He arrived at flight school married to an officer who was given a leadership role in our battalion. After some time, his wife became my company commander, but the relationship between he and I had already progressed. During their divorce, both he and my company commander sought comforts outside of their marriage. Then, a different flight school classmate of mine sexually assaulted me. When it occurred, my classmate married to my commander was the only person who I trusted enough to tell what had just happened to me, to discuss filing a report, and to care for my well-being. The sexual assault occurred on a Sunday, and I reported it the following Tuesday. On Friday, I was informed that Fort Rucker's Criminal Investigative Division was investigating me for adultery with my commander's husband, not even 3 days after I reported my sexual assault. It became immediately clear that the Army and its Criminal Investigative Division showed more interest in the affair rather than in the sexual assault. The following conflicts of interest occurred thereafter. My commander's position of authority gave her immediate access to my higher levels of command, my prosecutor, the investigators, and my cadre members. Prior to my report, my commander contacted the prosecutor, who would eventually be assigned my case, about personal business, seeking advice for a personal investigator to investigate her husband's suspected adultery. When her husband came forth as a witness in my case, the prosecutor linked my case to my commander's personal situation, and I believe that hurt my case's ability to move forward to trial. My commander also had a pre-existing relationship with the installation commanding general, the two-star convening authority responsible for deciding if my sexual assault would go forward to trial. Previously, the general was her brigade commander while she was a lieutenant at Fort Campbell. She requested his audience about the matters of her divorce prior to my sexual assault investigation concluding. This, too, I believe, hurt my case's ability to move forward to trial. Unfortunately, I did not have a commander who was able to serve in the best interest of a sexual assault victim due to these and several other personal conflicts. The incestuous nature of the relationships found in my chain of command made it impossible for me to have a truly objective case. There were many injustices throughout the investigation and thereafter. The most haunting is how the evidence that I volunteered from my body to process my rape kit was later used to substantiate adultery claims instead of provide justice for the sexual assault. Despite the overwhelming quantitative evidence that my assailant violated my body, the results only seemed to confirm my mischaracterization as an adulterer. My brigade commander initiated a commander's investigation for inappropriate relationships and adultery with both my witness and assailant prior to the conclusion of my sexual assault case. I was given a general officer memorandum of record from the previously mentioned commanding general, which was filed in my permanent record and effectively ended my career. The following are excerpts from the Army's internal investigation into Fort Rucker's sexual assault failures, which resulted in response to me reporting these injustices to Congress. Quote, that victim advocates and the Criminal Investigative Division at Fort Rucker provided outdated forms to sexual assault victims that did not fully inform them of their rights, particularly if the victims are suspected of misconduct, which includes representation by a special victim counsel. The brigade did not properly maintain hard copy records of these forms as required by law. The commanding general's extensive travel and improper delegation of sharp program duties to levels of command lower than that required of the minimum TRADOC standard led to a deteriorated monthly sexual assault response board. During that same time, the brigade did not have a sexual assault response coordinator for a 9-month period. Command-subordinate relationships, and I quote, show obvious conflict of interest. This led to lack of lower-level command support for victim and confirms her complaint of feeling isolated, end quote. All I ever wanted to do was serve my country, lead American soldiers, and fly the Apache helicopter. The loss of my military career and my inability to trust larger organizations such as our military has deeply impacted who I am today. I struggle with accomplishing even minor daily tasks, and my quality of mental and emotional health has greatly deteriorated. I hope this testimony highlights that pre-existing opinions about an individual can greatly influence the execution of justice in our military. This can negatively impact either the victim or the alleged offender. If my case were handled outside of my chain of command by a truly objective and trained legal professional, I do believe the outcome of my case and life would be different. Thank you again for your time.
Thank you, Ms. Babb. Colonel James.
Senators, thank you. I really appreciate the opportunity to be here, and these comments by all here are very riveting, and I appreciate it. My name is Doug James. I'm an Air Force retired colonel, fighter pilot by trade. I flew the A-10 and the F-15. Now I'm honored to be here as president of a nonprofit supporting what we believe are innocent service members. Since our inception in 2015, Save Our Heroes has received approximately 300 cases. A large number involve allegation of sexual misconduct. Most of those have been vetted, unfortunately reveal a staggering level of false allegations. The false allegation cases all have similar motives: contentious divorce proceedings, breakup of a relationship, or something as simple as a PCS or a permanent change of station move. I'm here to offer testimony as president of Save Our Heroes, specifically our nonprofit's view of the military judicial system. Let me state unequivocally that our organization, Save Our Heroes, deplores any form of sexual harassment and assault, and when facts and evidence are present, those found to be responsible should and must be held accountable in accordance with the rule of law. With that said, our organization strongly believes the Uniform Code of Military Justice has become a threat to national security. Our experience reveals there exists an epidemic of military law enforcement misconduct, procedural misconduct, unlawful command influence. The common thread of career killing, family destruction, and the lack of holding false accountants accountable has turned the military judicial system into a silent killer and what we believe a threat to national security. I don't say that statement lightly and understand the sensationalism. The way the military currently addresses allegations of sexual misconduct, everything from the initial investigation through the procedural and administrative stages, is not working. Unfortunately, there is not one silver bullet that can fix the problem. But interestingly, there is some agreement amongst this panel on how to start. All of us sitting here understand the system is not working, and we all seek justice. We share the understanding the military system is not built nor designed for justice. It is designed to maintain good order and discipline. Justice is different. Justice expects those falsely accused to receive a vigorous investigation in which the truth comes to light, where the innocent are not forced to a court-martial out of fear to protect a career. Justice also expects the same vigorous investigation when assault has occurred. The Uniform Code of Military Justice is just really a code. Leave justice out of it. It is a system built on a commander's discretion. If a commander believes a case should move forward, regardless of the innocence of the accused, it happens. If a commander believes a case should not move forward because it will not serve him or her in the pursuit of good order and discipline, well, that arbitrary decision is allowed too. Military decision is designed to handle military issues. Non-military issues such as sexual assault are best left up to the civilian authorities. That is why Save Our Heroes believes congressional pressure has been ineffective. Congressional pressure, whether direct or indirect, has pushed innocent service members to court-martials with no legal basis and has not served the needs of real victims. I'm sure it was not your intent, but we found congressional pressure has exacerbated the weakness of the system. Commanders are not interested in the truth, but more interested in appeasing Congress. We see commanders doing everything possible to convict someone for something they didn't do just to protect their career. At Save Our Heroes, in reference to the UCMJ, we say guilty until proven guilty. Some investigators use underhanded tactics with the goal of disregarding the truth. At a minimum, convict the accused for some sort of derivative collateral charge. Why? A conviction for a collateral charge allows the government to statistically show a sexual assault conviction. Most importantly, we see the service is shifting to non-judicial punishment because they know a baseless allegation would not be validated in a court-martial. The military's a logical solution to use non-judicial punishment is almost impossible to defend. Most shockingly, we have seen commanders willing to falsify facts to justify their decisions with NJP. Again, the services can show Congress they're handling the problem in an attempt to maintain their convening authority. Your statistics in this hearing show congressional pressure is not doing what was intended. This can't be a Band-Aid fix. A shock to the system is required to change a culture of legal corruption, which has permeated the military chain of command. I know there is some discussion about removing the convening authority, but I caution you. In 5 years, Congress may feel the military has a problem with some other crime, maybe spousal abuse, as an example. Are we going to make similar changes then? The changes must be able to pass the test of time. In conclusion, I understand the politics associated with this issue. I stand by my strong statement. This is a threat to national security, and something needs to be done as soon as possible. When I took an oath, I pledged to defend the Constitution against all enemies, foreign and domestic. I believe the UCMJ in its current state is a domestic threat to national security. Thank you again. It's an honor to be here, and I'm prepared to answer your questions.
Thank you, Colonel James. We could have the staff clear those 3 chairs between Senator Scott and Colonel James so they can actually see him. I'm going to yield or put my time on the end and yield to Senator McSally for the first questions, then Ranking Member Gillibrand.
Thank you, Chairman Tillis. And I again want to say thanks to Lieutenant Commander Elliott and Ms. Batt for having the courage to share your stories. I am sorry for what you went through, both with the assault and then also how you were treated afterwards. And so thank you for being an example of courage for all of us as we all have a common goal to try and stop this from happening to anybody else. I'm really grateful for you. Colonel Herring, it's good to see you again. We've worked together for many efforts to try and open all positions for women in the military back at the time where they were closed. So I'm grateful for your longstanding commitment and study and leadership on these issues. Part of what your testimony shares and what I've heard you talk about before and what we've talked about before is the underlying root causes of much of what we're talking about here, which is the culture. How do we address the culture of our military, who is, again, responsible for fighting and winning America's wars, who is responsible for the men and women under their care in a very power-based relationship that is very difficult for many people to understand. How do we ensure that that culture is one of respect and honor and dignity to include everyone, men and women, not being assaulted, not being retaliated against, not being harassed, and everything on the continuum of harm? What are your views on that?
Thank you. That's like lined up my very first response here perfectly, because it is a cultural problem. And I think that changing the UCMJ will ultimately, not an immediate, but an ultimate impact, will ideally improve the culture, because it will, so culture is at the root of the sexual assault problem in the military. Sexual assault is simply not seen as a serious crime. Until it is viewed as a serious crime and treated as a felony, it will continue to pervade our culture. Removing commanders from the decision-making process sends the signal that there are some crimes that are so severe that commanders have no place in deciding if, when, or how they are prosecuted. I believe that it will fundamentally shift how we view assault, sexual assault, and ultimately impact our culture in a way that says this behavior is absolutely unacceptable. So that's why I think that it's important to move commanders who I don't have the same confidence in their skills or abilities as you do.
Yeah, thanks, Colonel. I mean, I appreciate the perspectives of everybody on this panel. I respectfully disagree for some of the reasons that I shared. I don't want to take up my time talking more about my strongly held views on that, but there are other cultural underpinnings of what we're talking about here that, again, create an environment. I can't figure it out. In all my years, I talk about how you have high school kids go off to basic training and they're okay with having a female valedictorian or class president, but somehow they get inculcated where there is this resentment that could breed harassment and abuse of power and assault. So that's what I'm trying to get at. You're the one with the PhD. What are the other issues in the culture that we can be working on together in what we can agree upon so that the military is known and the commanders are equipped to be leading with honor and integrity and ensuring that there is dignity and respect for everyone under their command?
Yeah, that's a great question, and a lot of PhDs have studied this problem, and we haven't come up. If we'd come up with the answer or solution to this, everybody would know it by now. It is culturally based. I don't have the answer for you. I just think it's going to take a long time. It's going to take multiple pressure points. I think the UCMJ is simply one pressure point or one change, but there are many more that need to occur.
Yeah, I don't want commanders to be off the hook. I need them to be more responsible for solving this issue and every other issue that degrades good order and discipline in our ranks. That's what America's mothers and fathers, sons and daughters, husbands and wives have asked them to do, and they need to step up to that responsibility. Lieutenant Commander Elliott, thanks again for sharing your horrific experiences. It sounds like you've experienced the best and the worst of command and how they dealt with you. Did you have a special victims advocate through this process at all? And can you just share, if you did, what that experience was and how they interacted with you?
Yes, I had are you talking, Senator, about the lawyer or my victim? Okay.
Yes, sorry, the lawyer.
Yes, ma'am. I did have a special victims counsel.
Yeah.
Yes, ma'am. And she was with me every step of the way. I retained her probably about 3 months after I made the restricted report, prior to when I started thinking about going unrestricted, and so I had some concerns, as a lot of people in the military do. And so she was with me, and she was a great service from when I retained her all the way through the court-martial and even after that. So,
other than changing commanders, which sounds like needed to happen, other than not having people like your commander in command, what else would you change in the process and the experience that you went through?
When I moved, when I became in command myself, and when I was treated like that, I felt like I had no option. Like, I felt like if I tried to say, hey, you're saying this or doing this or whatever, that I would lose my command. I feel like that we need to have, and maybe at the time I wasn't, in the right mindset for that, but we need to have a better process for, reporting retaliation and who we can talk to about, because if we report it and then it's investigated by the same command, it's like, what's going to really happen? I feel we need an outside process for that.
Well, I agree, and some of the experiences I observed in the military, where clearly there was retaliation in the ostracizing and isolating the individual, especially when they're in the same unit. I know that wasn't the case with you. Again, people take a very complex issue and they come down on either he's a rapist or she's a liar, and then everybody has to still go to work together. And then there is this isolation and by peers, not just by superiors, but by peers, that sometimes is the cruelest. Did you experience that?
Absolutely. When I went to go be in command overseas, I was. There was someone that was known as the guy for our boss. You know, he could do no wrong according to our boss, and he was the one that my boss told my personal counseling information to. He came up and yelled at me, told me I was making it up, you know, and I was a horrible officer, all sorts of things like that, and I mean, left me in tears. And since he didn't like me, it was other people stopped inviting me to stuff. And then, in fact, he was sent later on to do inspections on my ship, be the lead inspector, and you know, was extremely critical, even though my ship had outside inspectors who done very well. So,
Senator McSally.
I know I'm over time. Sorry.
And I'd be happy to yield to another round if you choose to. Senator Gillibrand.
Thank you all for testifying. I'm exceedingly grateful. I was very grateful for Senator McSally's personal testimony, and I am deeply affected by that testimony. I want to talk a little bit about the questions that she had, because I think these are the questions. What the senator said is that she wants to make sure that commanders stay in charge because she believes they need to be preventing, protecting, and prosecuting these cases. I agree on the preventing and protecting. I just disagree on the prosecuting. And when we say you can't take commanders off the hook, the intention is never to take them off the hook. In fact, the biggest problem is because the military insists on keeping them in charge when they have a poor record of enforcing cases against sexual assault and investigating these cases, we don't actually hold them accountable. There's no leverage to hold them accountable at all. So, Commander Christensen, if we take this decision out of the chain of command, are we taking commanders off the hook? And what's your view on what the impact actually will be in their ability to continue to maintain good order and discipline and do their jobs as commanders?
Yeah, well, thank you, Senator Gillibrand. That's a great question. So, no, it doesn't take them off the hook. And I think one thing that is lost when people talk about commanders' role, the vast, vast, vast majority of commanders do not have prosecution authority. Senator McSally, as a squadron commander, did not have prosecution authority. That was at the special court-martial level or the general court-martial level. Only about 140 general court-martial convening authorities in the most recent data we have actually sent a case to trial. We are talking about those 140 people making that decision. Everybody below that has the same exact authority. And so you have a commander who did what the commander did to Lieutenant Commander Elliott. That person is still on the hook for that bad conduct. A commander has the absolute obligation to be taking care of victims and the accused, just as they would if that far away general court-martial convening authority has the authority or not. It does not change anything at all. But what one thing does change when we talk about accountability, right now, if you try to hold a commander accountable for making bad decisions when it comes to sexual assault, it creates the concept, it violates the concept of unlawful command influence. The Court of Appeals for the Armed Forces is very serious about that right now and is overturning case after case where there is absolutely no question about the accused's guilt of rape. And it's being overturned because of unlawful command influence, because of this idea that somebody was going to be held accountable. General Franklin in the Wilkerson case is the perfect example. He was held accountable. He was relieved of command, forced to retire, and as a result, we've had other cases overturned for unlawful command influence.
Okay, thank you, Colonel. Continue on with Senator McSally's questions. One of the things that she asked that I thought was a very good question is, how do you change the culture? And, you know, when we've asked service members, what would you do, what would make you actually report? Overwhelmingly, they have answered if you took it out of the chain of command, because they're not reporting, because they don't have the faith, as you did, Ms. Babb, that your actual commander had your back. I know from the many examples of sexual assault we've heard, the assault often comes from the chain of command. And so if there's an inviolate chain of command, that if you don't believe your commander is going to have your back because they're the assailant, then you don't necessarily believe his boss or his boss is going to have your back because of that chain. So from a survivor perspective, we've heard over and over again that the reason you take it out of the chain of command is because you want someone who is actually trained to make the decision, a technical decision. Is there enough evidence? To you, Colonel James, you were very clear that you're very upset because the scales of justice seem tipped, that if a commander just has to be aggressive about making sure there's no sexual assault under his command, they're going to prosecute all cases, whether or not there's evidence or not. We do not want one. It is as egregious for a guilty man to go free than an innocent man to be convicted. Equally as egregious. Justice is blind. So to the question I want to ask about this issue of culture. In your professional opinion, Colonel Christensen, as a former JAG, do you think the MJIA Improvement Act, if we passed it, which would establish an independent chain of command of prosecutors to make the decisions for the most egregious felony crimes across the board as all felonies, as stated by other early panel members, do you think that would allow more perpetrators to be brought to trial, and would we be able to protect more innocent defendants if we had a more clinical and professional way of handling these cases with no bias? Do you think it would then affect the culture because we'd actually be convicting people who are guilty and not convicting people who are not guilty?
I absolutely do. Right now, we have a system where we have people on both ends who have no faith in the process. If you have faith in the process, that independent prosecutors, and there's ample surveys have shown, such as IAVA, Iraq, Afghanistan, Veterans America, where they show that people have more faith of independent prosecutors have this. They also would not diminish their view of the commander. That we will get to the point where we can start moving that cultural ball. The Air Force Academy, the other academies have been fighting this culture issue. They haven't been able to get at it, and yet they prosecute almost nobody, despite having a horrific amount of sexual assaults at those institutions.
And just last, Commander Elliott, do you believe that if we did change this system, if we allowed trained military prosecutors to make these decisions, not commanders, that it would change the retaliation rates and the perception of retaliation by survivors?
Absolutely. I believe that both the perceived and real retaliation rates would be far less. Like people would feel a lot less retaliated, and that's on both sides, both the accused and excuse me, it would remove bias from all the sides too. I've talked to other victims who, like, they've been retaliated against, like, oh, well, you made the CO do this, you made the commanding officer, excuse me, do that because, you know, by reporting this, they're retaliated against because, like, they had, you know, these sailors had to leave because of something you did. If it wasn't that bias and that retaliation wouldn't be there if the COs or commanding officers are not making those decisions.
And even if you take this decision outside the chain of command, isn't it not still the commander's responsibility to ensure good order and discipline and make sure you aren't being retaliated against? That still is in their hands, and that's what they're not doing. They're not even doing the things that still rest with them.
I agree with you, yes. I mean, it is, no matter what, you always have good order and discipline that you're in charge of as a commanding officer. And like I said earlier, I believe some crimes are so bad that we're taking this seriously and we're moving this outside the chain of command. That's how serious this is.
Senator Rounds.
Thank you, Mr. Chairman. First, let me just say thank you to all of you for sharing these episodes in your life. Colonel Christensen, in your view, and given your significant military experience and your engagement with victims of sexual assault, what policies and programs have you observed to be effective in the prevention of sexual assault? Are there some programs out there that have been successful?
Senator Rounds, I think there have been. I think the training, although it's often maligned, I think it has raised awareness among the men and women in the services. When I talk to younger service members, I talk to cadets at the academies or cadets in ROTC, I have hope there because I think they are in a better position than the people at my age are in the service. So I think those are working. I think one of the most significant reforms that has been made is the creation of the Special Victims Councils, the Victims Legal Council. That advocate in the corner of the victim when they weren't there before has been a game changer for victim confidence. And so I think also where we have talked about the deglamorization of alcohol, Senator McSally would know that decades ago, alcohol was a huge problem in the military. We have pushed that back. And I also think when we look at the sexual assault numbers, cracking down on hazing and initiation is one of the reasons the male sexual assault rate dropped so much between 2016 and 2014.
I'd also like to touch a little bit on retaliation. In past testimony, you've suggested that most retaliation suffered by the victims of sexual assault comes from their peers, from social ostracism, from social media bullying and shaming. And in your view, how can the military system best tackle the online retaliation? I mean, look, young people today, they're all online. How does the military deal with this? If there's an employer situation, in many cases employers have taken different approaches. What's the appropriate way for the military to approach this?
Well, number one is be aware. There's only so many military publications out there, Air Force Times, the Military Times, Stars and Stripes, where you have comments. And all you have to do is look at the comments on any kind of article dealing with sexual assault, and they're horrific. And oftentimes those people writing those comments are putting their Facebook name right there, or any other major newspaper that's covering that issue. Just look at it and start holding the people who are making these horrific comments accountable. There's freedom of speech, but that doesn't allow you to bully your fellow members. So be aware of it. Number two, set the standard. Make sure that you are addressing sexual harassment. The sexual harassment rates are so high, both in the active force and at the academies, and yet we see no one ever held accountable for it. I believe there were 2 Article 15s given out the last year. We have numbers for retaliation. You know, start taking some people to court. It's okay. It's a discipline tool. Use it as a discipline tool.
Colonel Herring, same approach with retaliation. I see you nodding your head. Your thoughts on this in terms of your professional judgment. What's the appropriate way to address the issue of retaliation?
I have to go back to our earlier discussion on culture, and I wish I'd had a better formulated response, because I think it's a multi-pronged attack that we need to take here. It's not just one thing. Changing the UCMJ isn't going to solve this problem alone. I think there are multiple things that we need to be doing. Senator McSally, we have long struggled to even the playing field, allowing women these jobs that they were not allowed or were not viewed as capable of doing. I think that kind of changes the mindset of the way we view women, rather than a lesser subcategory of the military. But these changes are happening now, and it takes time. I think it's many things simultaneously, and I just think this is one of those things. The other one is, you know, letting women serve in all positions and seeing women who are capable and qualified, and that will change the way we view women, and then the way that we treat them. And then the retaliation thing. That's a commander issue right there, but that's not something that the UCMJ, and you made a good point. When have we held commanders accountable for the way that they treated? We never have. We never do, as far as I can tell. Very few cases of retaliation are ever brought to trial and then are found to be found.
Thank you. I'm out of time, but thank you, Mr. Chairman.
Senator Duckworth.
Thank you, Mr. Chairman. Let me just remark on how in awe I am of the bravery of Lieutenant Commander Elliott and Ms. Bupp for your testimony today, and also of my colleague, Senator McSally. Let me just start off by saying that I do agree that the military has shown that it has utterly failed at handling sexual assault through the UCMJ process. And I certainly do support removing sexual crimes out of the UCMJ process. But here's where I struggle. As a former commander of an assault helicopter company myself, there are crimes that I want to remain in control of for good order and discipline and the functioning of my unit. For example, violent assaults that are not sexual in nature, that have to do with racism, hate crimes, that sort of thing. And then that's where my struggle is. And certainly our ranking member has been so kind in working with me, and we've been working on this for years. And Martha, you have as well, you know, from our time in the House. And this is something we struggle, and when we, and I have to say, I still don't see the improvement in the UCMJ process in the military. And so I remain supportive of taking sexual crimes out, but I'm not sure that I'm there on all felony or even violent crimes. What I'd like to touch on here, though, is beyond the criminal convictions, which we're going to work on. You have a pledge that we will keep working on this. The criminal convictions do provide some sense of justice, but I still don't think it makes you whole. Not that you could ever be made whole again in the way you were before. But what is there that we can do to make the lives of survivors better? What more can we do for survivors to make sure that they have what they need to process and heal? And that includes stopping the retaliation. That includes letting you resume your careers and be successful in the careers that you dreamt about from the time that you entered the military. Could Colonel Herring, Colonel Kirsten, could you talk about that? And maybe the four of you could talk a little bit and touch on what would make it, and I hesitate to say better, but what else can be done?
Well, it's very controversial for some reason, but I say start by believing.
Yes.
There's from the survivors we talked to, protected offenders, survivors I talked to when I was active duty, it is very hurtful when they feel like their chain of command's not believing them and not supporting them. And so start by believing doesn't mean you're going to prosecute. Just start by believing means I accept that you have been through this traumatic event and I want to be there to help you. I think Congress has done a great deal to help survivors on the back end with the VA. Still ways to go on that, but the survivor community appreciates that. The other thing is just being able to flourish after this happens and understand that any survivor who's gone through trauma is going to have stumbles. And don't hold those stumbles against them to the degree that they're driven out, as the DODIG has shown. Give them that chance to thrive in the environment even after they've been assaulted.
Thank you. Colonel Herring?
Thank you. There have been a bunch of changes to try to assist victims, and I think the victims can speak more directly. We do see a lot of victims at SWAN, or we hear from a lot of victims, and one of the things they've asked for is an actual legitimate anonymous reporting mechanism, not the restricted versus the unrestricted reporting, but something similar to what has been developed and has been fielding on a number of university campuses and now is getting actually some widespread coverage. It's called it's Callisto. It's an anonymous reporting system or database where a victim can report their assault and their assailant, just put it into a database. And then what happens is they connect victims that have the same assailant. And they allow those victims to connect with each other. And then you're more likely, if you're not alone, if you have you've been assaulted by somebody that assaulted another person and now you've connected, you're more likely to come forward. You're more likely to be mutually supporting to each other. That's one idea that we have recommended to DOD, and I understand that this summer they may be fielding something similar for the very first time. It's a way for victims to tell their story, to unburden themselves in a certain way, and then potentially be connected to somebody else who was similarly assaulted by the exact same person.
Senator, excuse me, I think there's a couple ways to go about it. First of all, commanders need to be trained better to understand that every victim is different.
That's not you.
Oh, sorry. That was me. Okay. Every victim is different. You know, I wanted to go to work. And I focused on work. I knew a victim on our ship, and she got transferred off, and she needed a lot of time to process. The other thing is discussing our training. We've improved our training a lot, but I still don't think we address it appropriately. Like me, when I was going through this, I'm an officer. I'm the third highest ranking person on the ship. This doesn't happen to me. This happens to these junior people. You know, the women are raped in our training. The men are grabbed, you know, body parts put on them. They're not raped. Why don't we address the problems? We're still not doing effective training.
Yes, so I believe just have more of a preventative before you even get to be a victim. And I think that that comes from a true understanding, and going back to Senator McSally's comment about how do we change that culture. So I think that right now sexual assault is seen as a fear-based knowledge, and it's not taken seriously. I personally, after graduating from the academy, did not believe in the sexual assault response program, just for many reasons, and it took a truly inspiring leader who I reported to. We had a candid discussion one day prior to my sexual assault even occurring, and the way that he was able to passionately stand up for women who he has experienced while he was in command. If we could put those leaders, identify them, truly incentivize them to become these advocates, and not just randomly assign the role, but people who actually want to be there and want to be able to protect past, future, and every type of victim. I believe that that would help change the culture. And having people stand up. We have signs that say stand up, speak up, see something, say something. And honestly, as a victim, being in the Army after a year while I was waiting for this trial, it was insulting to see these signs in the hallways, to see my victim advocate still posted even though it was not a good experience for me, and to see people draw mustaches on them. Sharp as a joke. We need true leaders to stand up and truly train what we need our soldiers to be expected of, hold them to the higher standard. Knowledge, teach them how psychologically to recognize these signs of predation. That was a really big for healing and for me, understanding what had happened to me, understanding the cycle of abuse, and if commanders could be able to recognize this abuse cycle instead of blaming the victim and instead of maybe even blaming the alleged, they're more knowledge and they have the power still. So.
Thank you. You've been very generous, Mr. Chairman. Thank you.
Senator Scott.
First, I want to thank everybody for being here. Senator McSally, Lieutenant Commander Elliott, Ms. Bapp. I mean, I've got 2 daughters. It's disgusting that these things happen. And you, raising daughters, you're always scared to death that this is going to happen to them. And so it's very disappointing that anybody would do this to another human being. For Lieutenant Commander Elliott and Ms. Bapp, when you reported, are you assigned counsel? How's it work?
So are you talking about the victim's legal counsel?
Is that what do you have counsel that's going to represent you?
Yeah, yes. So from my experience through the court-martial, I realized I'm merely just a witness for the government. But yes, so the victim's legal counsel, they're a lawyer who's there to represent my interests through the entire process. Okay. And they're with me every step of the way. And you're not assigned that, you retain them. So like if I met a lawyer and I didn't like that victim's legal counsel, I could go to another one.
But you don't have to pay for it?
No, sir.
Okay.
No, sir. No.
And you had the same thing?
No, sir, I did not. I was given an outdated form that did not have a special victim counsel. I had never even heard of a special victim counsel. It took me contacting my colonel aunt. She's retired brigadier general after serving 30 years in the Army. I contacted her and had to share my personal experiences, and she was floored that I've never heard of one or wasn't given one. Once I had one, things felt a lot better, and he was able to provide services for me. However, at a certain point in my investigation, since my commander, it was a small installation, she had gone to him for seeking some advice prior. He technically represented her. There was a conflict of interest, and I lost one truly person who had my back. So it was a great loss for me and something that I wasn't even afforded the opportunity to have in the beginning.
So what did they tell you in the beginning? Did they tell you that, did they give you advice that this is not going to go well? I mean, how did they handle it?
The victim's legal counsel, Senator, no, they're actually there to support our wishes. Mine, like I started restricted and then I went unrestricted, and I talked through all the legal processes of that, and just going through the things that I were scared of, the things that worried me. She was just supportive, and whatever decision I wanted to make is the one. I remember she told me at one point, like, even if you change your mind right before you want to testify at a general court-martial, she's like, if that's what you tell me, then that's what we'll do. Like, so they were there. They're very supportive. And Unfortunately, the Navy only has victim legal counsels for sexual assault survivors, but other services have them for domestic violence and that sort of stuff too. It started expanding, so.
So you had a different experience then?
Yes, sir, I did. So when I first reported, I reported to a victim advocate who is not a legal counsel. I expressed my concerns with adultery, and I would like to take the time to say that I do not believe in that. I was very naive, 22 years old, graduating from the academy. I had no idea that that was where these friendships were headed to, but I did express to her my concern when it said collateral misconduct, and she brushed it off, said, oh no, that's like if you're underage drinking or something, you can't get in trouble for that, so no, you're good, keep filling out the form. So that was my experience with my collateral misconduct on the day that I reported.
And then once there was a conflict, you got nothing?
I sought out the special victim counsel at that point, and he was very helpful, as I mentioned prior. He was a little hesitant just knowing the 3 lawyers inside the case, knowing what the prosecutor had known, that my commander had reached out to him with personal business that just inevitably taints the investigation and makes it subjective at that point. You just can't deny that knowledge, so.
Right. Yeah. Colonel Christensen, you said a high percentage of the cases that go to trial are still, there's not a conviction. Is there a common theme of why it doesn't end in conviction?
Well, that's like an hour-long answer.
Yeah. I know, so I'm sure every case is a little bit different.
Every case is a little bit different, but there are systemic issues where the UCMJ is written that I think skews heavily in favor of conviction. The voting process, unlike the voting process in the civilian world where you reach a unanimous verdict, both either guilty or not guilty, so you have a consensus verdict. In the military, there's one vote. And it's, if you receive now 3/4 guilty, you're guilty. If you receive less than 3/4 guilty, it's not guilty. And so I think that skews very heavily in favor of not guilty verdicts because there's no compulsion to reach a verdict that everybody agrees with. So I think that's one of the problems. Another problem too is that the military has resisted I'm assuming that the TJAGs will testify this isn't true, but they have resisted efforts to allow people to become real experts at this throughout their career. I left when I was 4 years ago. I was the only colonel prosecuting in the Air Force, and I don't think anybody's prosecuted since. Why is that important? Well, sexual assault are complex, and it takes a long time. On the flip side, the accused can go out and hire the most experienced defense counsels in the world in the military justice system, and they're going up against 2 to 3 year captains. And so there's an imbalance, too, in that arena.
Thank you.
Thank you. Colonel James, I'm kind of curious. I know some of our allies have moved to the framework that I believe most of this panel would support, and I'm kind of curious about what learnings they have. Are they in the same place they were when they first made the transition? I think many of them were motivated to make sure that they were, I think, making sure that the rights of the accused were being addressed. So I was kind of curious, what's been their real-world experience in terms of convictions, incidents of sexual assault? I don't know how long they've been in place, but give me some idea of how this movement has had a material positive or negative effect among our allied.
Sir, I'm not prepared to talk about our allies, but we'll certainly get back to you and report back, because I think that's a fantastic question. But I will say, following up with what Don said there about the reason we see a lot of these cases going to all the way to court-martial is there's not really a clear-cut definition in the DOD of what a sexual assault is in the first place. We have cases where recently where somebody just brushed up against somebody on a bus, and she claimed he looked at her like, you know, he wanted to have sex with her. And that's a conviction, and that's what non-judicial punishment is going to be used against. So that is one issue, and the other is training. There's not clear training amongst what sexual assault is. And this isn't just me talking. We've got multiple lawyers that we've talked to, military defense attorneys, that have worked through the system and think tanks that have worked through, and we're trying to figure out answers. And that's why, even though I disagree with Colonel Christensen Don on this one subject, we do agree that something needs to be done. And when I said it's a national security issue, I meant it. It really is. I also will disagree with him on UCI. I think there's a lot of UCI in the system. I can name off a bunch of cases right now. The Wright case, we've got the Chief Berry case, and we've got the Vargas case. Those are just a couple that came to mind when I was sitting here. So I will get back to you, sir, and your staff on that question.
I think it'd be helpful. It'd be interesting just to know the timeline, what their experiences have been, and what policy changes they may have made if they got out ahead of their blockers. I think that would be very helpful as we continue this discussion. Mr. Colonel Christensen, I know in some of your either past statements or past testimony, you've talked about the nature of retaliation. I think many people here who haven't studied the subject would think that this is a commanding officer's retaliation or, you know, superior officer's retaliation. Could you talk a little bit more about what we generally see as retaliation that victims are experiencing?
Sure. Well, the SAPR report looks at basically 3 areas of retaliation, and so you have retaliation from peers, and that's about 1/3 of it. You have retaliation from supervisors, that's about 1/3. Then you have punitive retaliation, and that's about 1/3. And
tell me a little bit about the punitive retaliation.
Sure. So these are self-reports from the survivors, and what they say is that after they report, kind of like what Lieutenant Commander Elliott's talking about, you have a career-ender, or what Ms. Bapp's talking about, you have a career-ending event. And that can happen a number of ways. So, for example, you can be very overt, and we're going to give you an Article 15, and we're going to court-martial you, and we're going to kick you out. Or it can be less obvious, and it's a downgrade in your performance report. For those of us who've been in the military, just changing a couple words in a performance report will end somebody's career. And so that's part of it. It can also be you don't get selected for the next level of school to go in residence, which will also hurt your career, or you may not get the assignment that you were hoping for. Those are very difficult to prove, but when you look at it systemically over there and you see so many survivors having that same story, you come to a conclusion that it's happening.
Thank you all. I want to move to the next panel. I know that we're going to be having a vote probably coming up in the middle of the panel, so I want to thank you all for your time here, and then follow up. We hope that I know that you've collaborated with members, and we hope you'll continue to do that. And Colonel Jameson, any others information that you'd like to submit for the record, we'd welcome it. Thank you, Lieutenant Commander Elliott, Ms. Bapp, and Senator McSally for your courage and your leadership. We'll now transition to the next panel. If we could get the witnesses to be seated, hopefully we can get in your opening comments, and then I'll figure out a way to transition in the hearing in the middle of votes. As the witnesses are being, as witnesses are being seated, I'll go ahead and introduce and then have you make your opening statements. Again, we may have some members go in and out once the vote's called, but we've got at least 15 or 20 minutes before that, so hopefully we can get most of your opening comments in. Our witnesses in the second panel include Dr. Elise Van Winkle, Executive Director, Office of Force Resiliency in the Office of the Secretary of Defense. Welcome. Lieutenant General Charles Peedy, the Judge Advocate General of the Army. Vice Admiral John Hannock, Navy Judge Advocate General. Lieutenant General Jeffrey Wackwell, the Judge Advocate General of the Air Force, and Major General Daniel Lecce, I know him as a colonel, Staff Judge Advocate for the Commandant of the Marine Corps. We'll start with Dr. Van Winkle and move straight down the line.
Thank you. Chairman Tillis, Ranking Member Gillibrand, and other distinguished members of the subcommittee, thank you for having me here today to discuss sexual assault prevention and response in the military. I am extremely concerned by the results of the most recent survey of the service academies showing another increase in sexual assault and about the trends and data that we are seeing. However, I sit before you committed and dedicated to making this right. To be clear, these are not merely data points in yet another DoD report. These are dedicated service members who volunteered and stepped forward out of commitment and loyalty to our nation. We have a profound, sacred obligation to our service members and their safety. The Department remains committed to our goals of ending sexual assault in the military, providing the highest quality response to service members, and holding offenders appropriately accountable. My office oversees the Department's programs and policies that address our critical challenges, including sexual assault, harassment, suicide, and drug use. All of the behaviors or issues we as a society have not yet solved. As the Department of Defense, we are the ones who have been entrusted by this country to lead the way. We must lead, and we are working to do just that. We assess our efforts in a number of ways using a robust data surveillance system. We conduct scientific surveys every other year to understand the scope of sexual assault and harassment in the force. We conduct focus groups in the survey off years to detect emerging issues. And we study sexual assault reporting data each year so we can understand more about those who made the courageous decision to report. While we want annual prevalence, that is, the number of people who experience sexual assault each year, to go down, we want the rates of reporting to go up. We have been measuring ourselves in this fashion for more than 10 years, and our last survey with the active force in 2016 found that overall past year prevalence of sexual assault had decreased over the past decade. Our rates of sexual assault reporting more than quadrupled during the same time frame, but we are not seeing the same trend in the military service academies, and that is gravely concerning. In addition, our surveys indicate that retaliation is perceived by an appreciable portion of students and service members who make a report, and these types of behaviors gravely undermine all of our efforts in this space. And while we have seen some periods of progress, our history also shows that sexual assault rates can and do rebound, as they have in the academies. We know we must adjust our approaches as we analyze trends and patterns in the data and as the science evolves. Our early prevention and response efforts were necessary but not sufficient to reduce and eliminate sexual assault across the department. Measurable and sustained reductions require a strategic approach beyond training, and my written statement offers some of the strategies we will be employing moving forward. The path we are on together is not an easy one. No one action in isolation will take us where we need to be, and there is no single solution to the problem of sexual assault, but we are committed to this battle for the long run. This is not just another job assignment for me. My experience, both outside federal government and within the department, have made me eyewitness to the human toll that sexual assault can take. I have held countless hands in hospitals during sexual assault forensic exams and in courts during testimonies and verdicts. I have spent time holding a survivor as they sobbed on the floor of a convenience store because they saw somebody that looked a lot like the person that raped them. I have driven to a hospital at 2 in the morning because my client tried to take her life rather than live with the memories of her sexual trauma. And I have held on tightly to a 12-year-old girl as she looked through a photo lineup in a police department to identify her rapist when she was walking home from school. I have spoken personally to, and I have received emails from brave and amazing military members who want nothing more than to serve this country honorably, but have instead been subjected to this crime. This is personal. I take it personally. I am not alone.
I have spoken directly with the Acting Secretary of Defense, the service secretaries, and the military chiefs. I have heard their shared concern. I have seen their frustration and their commitment to eliminating this misconduct from the ranks. At every corner of our military, we must do better. We can do better, and we are capable of being better. We are committed to being transparent as we tackle this significant problem. Your interest, your insights, and your support are always welcomed, and I want to thank you for everything you do to partner with both my office and the department on this important issue. I look forward to your questions.
General Lecce.
Chairman Tillis, Ranking Member Gillibrand, and distinguished members of the subcommittee, on behalf of the Secretary of the Navy and the Commandant of the Marine Corps, thank you for the opportunity to testify today. Chairman, I enjoyed your visit to Camp Lejeune a while back. It's good to see you, sir. In addition to my formal written remarks, which I respectfully request be made part of the record, I would like to address the Marine Corps' efforts focused on sexual assault prevention and response. One sexual assault is too many. The Marine Corps strives to eradicate sexual assault from our ranks by capitalizing on the detailed work of congressional advisory committees and diligently implementing the many statutory changes made in recent years. Like sexual assault, retaliation is unacceptable. Eliminating retaliation is central to the Marine Corps' efforts to combat all destructive behaviors such as harassment, hazing, and bullying. The Marine Corps has developed a comprehensive and holistic approach to eliminate these destructive behaviors. In pursuit of these goals, the Commandant established the Marine Corps Personnel Studies and Oversight Office. Reporting directly to the Assistant Commandant of the Marine Corps, the Director of the Personnel Studies and Oversight Office assesses and provides feedback on initiatives focused on strengthening the Marine Corps' culture and mission readiness. In addition, the Personnel Studies and Oversight Office manages the execution of pending initiatives, collaborates with Training and Education Command on new curriculum content, and establishes advisory committees to ensure the Marine Corps and key stakeholders have an opportunity to participate in the process and meet current and future challenges. Further, nearly 1 year ago, the Commandant published a Marine Corps order on prohibited activities and conduct. Violations of this directive are punishable under the Uniform Code of Military Justice. This order first addresses a wide spectrum of conduct, including sexual harassment, hazing, social media misconduct, including the distribution of intimate images, retaliation against victims or those who report criminal offenses, and discrimination. Second, it requires all commanders to investigate all complaints and to protect complainants from retaliation. Third, it requires all complaints to be documented in a central database known as the Discrimination and Sexual Harassment Repository. And fourth, it requires all commanders to conduct follow-up assessments and to measure effectiveness through regular command climate surveys, both at the assumption of command and at the relief of command. As has been true throughout the history of the Marine Corps, commanders are central to the process. They are responsible and accountable for good order, discipline, and the welfare of all of their Marines. The individual Marine is our greatest asset. Commanders are responsible and accountable for ensuring all Marines are treated with dignity and respect. Finally, all services are in the midst of implementing the Military Justice Act of 2016. This is the broadest reforms to the military justice system since its inception. Many of these reforms are aimed at making the military justice system more fair and transparent, both to the public, victims, and the accused. I believe our collective efforts, briefly described above, will serve to strengthen the justice system and reinforce public trust and confidence in the military justice system. I look forward to working with you and answering your questions. Thank you.
General Rockwell.
Chairman Tillis, Ranking Member Gillibrand, distinguished members of the subcommittee. Military commands led by commanders are responsible for executing our national defense strategy to defend the nation and win America's wars. Throughout our history, we have accomplished this because of four simple yet key components: the best people, the best training, the best equipment, and fourth, the most important element that binds together the other three: discipline. Discipline lies at the heart of command and control. Commanders command and control airmen armed with the best training and equipment to execute our national defense missions. Discipline is commanders' business, since they have the ultimate responsibility to build, maintain, and lead the disciplined force necessary to succeed in combat across multiple domains. Discipline makes us ready. Discipline makes us lethal. To build this disciplined force to execute these missions, the military justice system works to strike a careful constitutional balance between all all competing equities in the process. That balance is best struck when, at every critical juncture in the process, a commander is armed with the relevant facts, including victim input, and advised by a judge advocate before making a decision on the next critical step in the process. We also know that good order and discipline is best when command operates and executes discipline across the entire continuum of discipline, from prevention efforts in setting standards, duties, and command climate on the left side of that continuum to the response of courts-martial on the right side when standards aren't met, and everywhere in between. This disciplinary continuum embodies the concepts of unity of command, unity of effort, and command and control needed to build a ready, lethal, and disciplined force to execute the missions the nation asks of us. This committee in Congress has been instrumental in our efforts to improve military justice, particularly with regard to sexual assault. You have focused the system to be more fair and timely to appropriately address allegations of misconduct that fosters progressive discipline designed to deter and rehabilitate wrongdoing, to respect the dignity of victims of crimes, to protect the rights of accused, and to maintain the trust of airmen and the American people. We have increased our commander training to ensure they are better prepared to exercise their authorities. Before taking command, all commanders receive extensive legal training so they fully understand their responsibilities under the code and the manual. Officers receive similar training at all levels of their professional military education, as do enlisted members. Most importantly, as a matter of process, safeguards have been incorporated and gaps closed to maximize legal advice during every key phase or decision point of a case through investigation, adjudication, and final disposition. Our existing statutory authorities mandate that this critical legal advice be independent. Like with all decisions, commanders never make them in a vacuum. Decisions are informed and evidentiary standards are applied at each stage of the process with the advice of a staff judge advocate, along with input from a prosecutor, victim, and accused. A critical component to our fight against sexual assault in the military has been our quest to build trust and confidence in victims. We know that victims must be empowered at every stage of the process. Survivors must believe that their privacy can be protected and that they can regain a sense of control in their lives. Sex assault is a personal violation, and victims must be heard without having the process itself further make them feel victimized. Victims must know that they have a say before any decision is made. Our Special Victims Council have become a vital teammate in our sexual assault prevention and response arsenal. Removing command authority from our process and efforts to date would have a negative effect on military discipline and readiness, jeopardizing ongoing efforts to combat sex assault through a holistic, command-based approach across the continuum of discipline, prevention, and response. Responsibility to uphold the broad system of laws set out in the Manual for Courts-Martial is not an additional duty for commanders. It is interwoven into the concepts of command and unity of effort. It is fundamental for our airmen to have no doubts about who will hold them accountable for mission performance and adherence to standards 24/7, both on and off duty. Our work must continue to prevent and respond to criminal behavior within our ranks. With our holistic focus, we've seen increases in victims reporting and seeking services, with a commensurate increase in investigations, prosecutions, trial, and appellate litigation. Our next steps, I believe, should focus on addressing evolving issues of retaliation, collateral misconduct, timeliness, and education on the general deterrent effect generated by the cases tried. While there has been much progress, we as judge advocates remain committed to survivors of sexual assault. We remain committed to airmen, and we remain committed to providing sound, independent legal advice to our commanders in a military justice system that has made us the most ready, lethal, and disciplined force in the world. Thank you for hearing us today.
Thank you. The vote has been called. It's a hard 15-minute vote, but this is the U.S. Senate, which means we've got about 25 minutes, and then they'll be back-to-back. So, Senator Scott, if you intend to ask questions, I'll yield my time to you so that if you'd like to ask questions before you go to vote. Admiral Hannock.
Chairman Tillis, Ranking Member Gillibrand, and members of the subcommittee, thanks for the opportunity to appear today. Our Navy guidance clearly states sexual assault is a criminal act incompatible with Navy core values, high standards of professionalism, and personal discipline. And as I listen to the testimony of the first panel, I'm reminded again of the importance of constant assessment and reevaluation of our efforts to improve our institutional capacity to prevent and respond to sexual assault. Everybody's role is important. From the sexual assault response coordinators and the victim advocates, they lead the response efforts, to the agents who investigate, and yes, to the colleagues who have to treat each other with dignity and respect. Our Navy regulations emphasize the great responsibility of the commanding officer for his or her command. And it states that the authority of the commanding officer is commensurate with his or her responsibility. In my view, it must remain so. And this authority should not be eroded. The contributions of judge advocates in our legal offices are also an important part of our capability. I'd like to highlight two areas. First, in court-martial litigation. The Navy JAG Corps established a litigation track in 2007 to improve the overall quality of court-martial litigation. This recognized that criminal litigation skills are perishable and that repeated tours in military justice billets are needed to develop expertise and competence to litigate complex cases, serve as judges, and then to train and supervise more junior attorneys. We now have 81 officers in the litigation track, including 13 captains and 25 commanders. And these officers, most of whom are at any given time in activities related to courts-martial, benefit everyone. They're the special victim investigation and prosecution trained prosecutors who work with Naval Criminal Investigative Service and then lead the independent prosecutorial review of cases and prosecute those that proceed to court-martial. They also serve as defense counsel, providing critical expertise in doing their demanding work, zealously defending those who are accused of crimes, and doing their utmost to ensure that any conviction only follows a fair trial that adheres to American constitutional standards of due process in a system that seeks justice. They serve as military judges, impartial arbiters of courtroom proceedings who must have as their only interest that everyone's rights are protected, the accused and the victim. And their efforts provide counsel to commanding officers who consult with judge advocates regularly regarding the disposition of allegations. The judge advocate, however, cannot replace the commanding officer's role in the process. The commanding officer must assess the effect of the offense on the morale, health, safety, welfare, and good order and discipline of the command. And second, I would say, related to the litigation aspect, is the work of our victims' legal counsel. These 33 attorneys, 5 of whom are currently drawn for the litigation track, are dedicated to serving individual victims. They explain the investigation process and the military justice process. They safeguard victim rights and represent their interests and serve as an advocate if there are concerns of retaliation. Of all military justice-related initiatives over the past 6 years, this program may have been the biggest positive impact on victim awareness, understanding, and trust in the system. But I know there's more work ahead. As the recent report related to the Military Service Academy showed, nothing can be taken for granted. And as the Judge Advocate General of the Navy, it's my responsibility to help look ahead and ask what else needs to be done. In that, I'm grateful for the work of congressionally chartered panels that have produced numerous reports over the past 6 years, from the Response Systems Panel to the Judicial Proceedings Panel, and the ongoing advisory committee reviewing the investigation, prosecution, and defense of sexual assault cases. The work of these panels has and will continue to inform my thinking, and I'm sure many others. I'm also grateful for the support of this subcommittee and the organizations represented by the first panel to ensure that we continue to make improvements to our response systems and prevention efforts. Thank you again, Chairman Tillis and Ranking Member Gillibrand.
Thank you. General Petey.
Chairman Tillis, Ranking Member Gillibrand, and members of the committee, thank you very much for the opportunity to appear before you. We have the best Army in the world, and our Army is the most effective force on the battlefield because our commanders and our soldiers are the product of a system of accountability that at its core has consequences. A justice system that for 243 years has rested in the hands of those who are responsible for the Army's mission to fight and win wars. That is our commanders. Like many on this committee, for over 15 years, I have worked directly on confronting the issue of sexual assault. In those years, I've worked on numerous legislative changes, most especially Article 120, beginning with the tectonic changes of 2007. I was personally involved with Secretary Garen's efforts to resource the fight and had a direct hand in the establishment of our Special Victim Prosecutor Program and later our Special Victim Counsel Program. So I appear before you, however, today recognizing there is still much work to do. Our first panel is a reminder of this sacred charge. As the Army Judge Advocate General, I tell you that we shall remain relentless in the Army and focused in getting after this problem and in the protection of our victims, our communities, and of course, and always the rights of the accused of these crimes. In short, the commander has always been and must always be the fulcrum to any solution in the Army. Look at our current housing crisis. We outsource responsibility for housing our soldiers to privatized partners. Who do our families look to for solutions? Who do you look to drive change? Soldiers look to their commanders. Every town hall is hosted by a commander. Will every commander deal with mold or leaky basements perfectly? Of course not. But there is no set of leaders on this earth better trained, better resourced, and more consistently successful than an American commander. And in my view, so it must be with sexual assault. All of us in this room recognize there is no easy solution. I've been fighting this crime hand in hand with commanders for 31 years. But certainly no solution in the military excludes commanders. The notion that stripping commanders of authority over serious crimes will reduce crime, results in more or better prosecutions or higher conviction rates, in my view and experience, simply is not supported by any empirical evidence. Indeed, the proposition is actually disproved by the empirical evidence. We know this. In the multitude of congressionally mandated studies where diverse panels of experts have exhaustively examined the military justice system, hearing hundreds of witnesses and thousands of hours of testimony, they reported back to you one critical, consistent conclusion: the commander should not be removed from the military justice system. The scope of the sexual assault problem and crisis is as big as the society from which we draw our soldiers. As you know, the Army is refreshed every year with 75,000 new soldiers from every city in America. We are drawn from our society, and we face the same problems. In a timely illustration of the breadth of the sexual assault problem, a highly esteemed university recently released the results of a prevalence study wherein nearly half of their female undergraduates said they were sexually assaulted since enrolling at the university, staggering 48%. These females reported an annual rate between 18 and 22%. I share these statistics not to place blame elsewhere or to distract from the Army's 4.4% prevalence data or the 18% recently reported at our military academy, or to suggest somehow that the Army is like a university, because it is certainly not. But the numbers of the university, at the university, speak to the pervasiveness of the problem in our society at large, especially within certain demographics. Despite the challenge, the Army owns this problem. Discipline is, as George Washington said so many years ago, the soul of an army. It's foundational, it's our DNA. In my professional view, taking away a commander's decision over discipline, acts of misconduct, including the decision to prosecute crime at court-martial, will fundamentally compromise the readiness and lethality of our Army today and on the next battlefield. Congress and the services have made unprecedented strides to attack this crime. Our statute's aggressive, expansive, forward-thinking. In Army courtrooms, 10 years ago, sexual assault offenses comprised 18% of Army trials. This past year, 50% of Army trials were sexual assault trials. Our statute gave voice to victims. Our SVC program gave voice to victims. We know there's much that remains to be done. We promise you we will continue to get after it, and I thank you for your time.
Senator Scott, I know, is going to go vote, and you had a brief question.
First off, thank you for your concern about this. Thanks for your service, and thank you for your commitment. So the first thing is, has anybody been held accountable, any commanding officers been held accountable for their failure to properly deal with sexual harassment? Does anybody have any examples of people that have been held accountable for not handling it the proper way?
Sure, I can tell you that we have, if we speak to retaliation issues, we have, I've got a number of cases this year in fiscal year 18 where I can identify command elements, either the officers that were responding to the allegations, similar to things described in the first panel, that were held accountable. I don't have evidence of courts-martial. I would simply offer to the committee that notions of retaliation comprise a spectrum, and some of it's very difficult to criminalize with criminal sanction. But that which is, we have a couple of cases where it resulted in a charge at a court-martial. But it is a very difficult thing to get after criminally, sir.
Senator Scott, one thing I will tell you is that one of the privileges that Senator Gillibrand and I have as the chair and the ranking member is that we're consulted with promotions that are sent forward. One of the questions that I've asked of the DOD is those are ones that pass muster within the department and each of the branches. I know that some promotions are held back as a result of some of these adverse activities being in the file, and then some make it past, a handful that come before us, and I will guarantee you if there's any credible evidence in a file, that person will never get promoted as long as I'm in the U.S. Senate. So there's that congressional responsibility as well. It's not foolproof. I do think that there are probably other actions that we need to take, but there are those checkpoints that you may not have been familiar with being relatively new to the committee. And Senator Gillibrand, I think Senator Scott and I are going to go vote. The cloakroom said they're going to close in about 5 minutes.
Okay. Lieutenant General Rockwell, your prepared remarks were inaccurate. You said that as further evidenced by an increase in investigations, prosecutions, trial, and appellate litigation. In fact, just looking at the last 3 years, we've seen such a reduction in performance. It's mind-blowing. In 2015, 46% of the cases were command action considered. In 16, 47%, and 17, 53%. So you'd assume commanders are looking at more cases and they'd actually send more to trial. No. So in 15, 33% went to trial. In 16, court-martials preferred. 33% were court-martial preferred. 16, 27%. In 17, 22%. You'd say, well, at least more must be going to trial, right? No. In fact, in 15, 20% went to trial. In 16, 13% went to trial. In 17, 11% went to trial. And you say, well, surely convictions must be up. No. In fact, in 15, 15% were convicted, 413 cases. In 16, 9% were convicted, 261 cases. And in fact, in 17, 8% resulted in conviction, 284 cases. So we're not going in the right direction on any possible measurable that you could create. And what I'm most disturbed about your testimony is that you feel you're doing a good job. And I'm just trying to tell you, if commanders are in charge of good order and discipline, then why do we have a 59% retaliation rate? Why do they allow so much retaliation to happen in the ranks, both professional, both career-wise, and both peer-to-peer? Like, all of these forms of retaliation sit within your jobs of maintaining good order and discipline. So I'm very concerned that you're not even briefed well by your people who are helping you to be here to testify, because I'm sure you didn't mean to testify a false statement, General Rockwell. I'm certain of that. But the person who wrote your remarks did not look at the actual facts. And so it's disturbing to me that you might not realize the depth of the problem, the depth of the absolute problem, and no one is trying to make commanders less responsible. Nobody. We would like you to maintain good order and discipline. We would like you to stop retaliation. We would like you to stop sexual assault. We would like you to prevent sexual assault. But when it comes to the technical decision, is if there's enough evidence, that 3% of you who get to decide this, let's leave it to an expert, someone who is trained in criminal justice, who's prosecuted cases and defended cases, somebody who has a career in it, because you're trying to make these decisions yourself, And it's only 3% of you anyway. It's not the average commander. And we're not making you less responsible. We're taking one thing off your to-do list that you're not very good at. That's it. We're just taking one thing off your list. And to say that we are making commanders less involved is a false statement. Because first of all, 97% of you never have the right to be a convening authority. You're just not senior enough. You're not there. You will never have that right. 97% of you have to instill good order and discipline and not have the right to decide whether a case goes to trial. When we had a hearing about Article 60 in the beginning of this debate 6 years ago, every commander said, oh, commanders must have the right to overturn a jury verdict. Because that goes to these things that you mentioned, Vice Admiral Hannock. You say we have to be able to assess the effect on morale, safety, health, wellness of the unit. Well, you insisted that you have this right. The second the Secretary of Defense said, yeah, it's a vestige of pre-World War I, we really don't need it, everyone said, oh yeah, it wasn't necessary. I promise you this is the same thing. You do not need to decide a technical decision about whether a felony has been committed. You do not need to do that because your job is to make sure the crimes don't get committed, to make sure they get investigated properly, to make sure there's no retaliation, and to make sure you have unit cohesion and that you actually have good order and discipline and you don't have 15,000 rapes, sexual assaults, and unwanted sexual contacts a year. So that's the truth of the matter. And so your testimony is leaving me wanting because I don't think you're up to the task. Every Secretary of Defense for 20 years has said zero tolerance. Never would you accept this level of failure for any other mission you're asked to complete. Never. And never would you say, over 25 years, we've been doing our best, zero tolerance, and still have a conviction rate of 3%. That's so sad. And yes, you're right, there's sexual assault everywhere, in society, on college campuses, in the military. And the reason why I'm spending so much time trying to professionalize the services is I want you to be state of the art. I want the world to look to the U.S. military and say, yes, we have the greatest men in the world, yes, and women, and we have the greatest ability to win wars and to keep national security. We have the best and the brightest. So why not give you the tools that I really think you need to be really good at this too? A lot of DAs around the country are terrible at this. DAs, they're professionals. They're terrible, their conviction rates are terrible because they don't handle sexual assault well. So why not, as the Navy has done, allowed for a professionalization of their JAG system to become career criminal justice lawyers. It's exactly what all the services should do. And then let the prosecutor make the ultimate decision about whether there's enough evidence to go forward to convene a court-martial. There's no reason why commanders shouldn't opine on it, shouldn't be part of the process, shouldn't influence the process, but just let it be a technical decision because as our defendants' rights advocates have said, why do we want to push the scales either way? I think a lot of commanders did overreact and say, oh, I'm going to send every case to court-martial. Well, maybe they did, but if you're sending false cases forward, you're not going to instill confidence in the system. If all of your cases that you move forward end up in not convicting and saying that it didn't happen, do you think a survivor is going to think that system works? No. So you only want to send forward the cases that actually have the legitimate basis and have the evidence that a prosecutor would look at and say, I could win this case. So I would love to work with all of you on trying to address how we deal with sexual assault better. I do not think you need to retain this right. I think it is a red herring to say we are making you less in charge. We're not. We're just taking one technical decision away. So that when Senator McSally testified she was actually assailed by her commanding officer, that a survivor can say the chain of command still has my back because you need to have their back. So let someone else decide who has no skin in the game, who just is going to make a technical decision on the merits of the evidence. I don't think you should fight me on this. I don't think you should fight the millions of survivors who have said this is the one change they want in criminal justice. It's all they're asking. It's the one change because they just feel like if there's no skin in the game, if there's nobody who's has a bias against the accused or against the accuser, that in fact justice might be possible. If you had a higher conviction rate, to Senator McSally's question, what do you do about the culture? I promise you, if more bad guys went to jail for sexual assault and rape, you'd have less sexual assault and rape. It's how it changes. So I've gone over my time. I don't have questions for any of you. I just want you to know that I deeply want to work with you on this. I want to solve this problem. I think our failure in this is embarrassing. One thing that Senator Tillis asked about was other jurisdictions. So Israel did it in the 60s. UK did it maybe 10 years ago. Australia, Canada, Germany, Netherlands, all of them took this one decision point out of the chain of command for one reason. They did it because of defendants' rights. They thought, if you can put someone in jail for more than a year of their life, why not allow a professionalized system to look at it? We know our commanders have so many responsibilities. We know they do an amazing job in winning wars and training troops. I don't know why we ask them to be good at sexual assault cases. It's the hardest case in the world to prosecute. It's the hardest case in the world to get right. People who professionalize in this area still don't do very well at it. So that's my only request is please work with me on these issues. Okay, I'm now going to put our hearing in recess to go vote. Thank you for your service, thank you for your commitments, and thank you for your dedication to our country.
All right, we'll have the committee come back to order. Turns out I was off by about 20 minutes. Apparently the 15-minute vote was roughly 40 minutes. So I suppose I may be the final person to ask questions. One of the questions, General Petey, I want to start with you. You were talking about the empirical data in your opening comments would seem to refute the benefits or that it would produce numbers that would, on their face, be an improvement. Tell me more about that and what the basis of the research was.
Mr. Chairman, yes, thank you. I was referring in particular to the various commissions' studies that have been directed through Congressional and DOD oversight, beginning with the Response Systems Panel, then followed by the Joint Judicial Proceedings Panel, and then now we have the Defense, well, it's called DAC-IPAD for short, but it's reviewing our cases, our investigations, and our prosecutions. So taken together, although DAC-IPAD is still meeting and their results are preliminary, Response Systems Panel spoke directly to the issue of the role of the commander. In fact, most, if I can say, in my experience with them, most were inclined to support Senator Gillibrand's bill as they began their work with that committee. In particular, Representative Holtzman was quite clear on the record that her mind was changed through the course of, I think, over 60 public hearings and thousands of witnesses' testimony. She changed her mind. She saw no evidence of that, taking the commander out of the process of justice would solve anything, whether it would improve prosecutions or anything. So her testimony, her statements are quite compelling, but the RSP actually published a statement to that effect as well, sir. The Judicial Proceedings Panel drew similar results. That's particularly what I was referring to, and then my own sense, sir, of the empirical data that I know, dealing with commanders and dealing with lawyers. My experience is that the desired end state of some kind of improvement, whatever that might be, if it's more prosecutions, higher conviction rates, will not result by removing commanders. So that was the context of my statement, sir.
Anyone else have to add to that? I've got other questions, but.
Sir, I would just add feedback I received from our victims' legal counsel is that, the role of the commander is not the thing that factors into the concerns that they're hearing. They deal a lot with the peer ostracism that was talked about at the last panel. But I think the sense that I get from them kind of reinforces what the Response Systems Panel indicated, which, as General Petey said, found no evidence that removing the commander would decrease sexual assaults or increase reporting.
I did want to go back and ask about, in the first panel, the discussion of the Fort Rucker incident and the Sharp office. Can I get some information from you, General Petey, on exactly what actions occurred after this was brought to your attention?
Sir, yes. And again, I would start by offering this committee and you, sir, an acknowledgement that we are not perfect and we will make mistakes, and that investigation, the manner in which Ms. Bapp described some of the errors in the processing of her allegation were mistakes made at the local level. And when we became aware of those, the Army took notice of that, and Fort Rucker itself conducted an investigation. And because of our concerns about what we were hearing, the TRADOC commander, the 4-star level commander, decided to conduct an investigation. So we had a very senior level oversight look that discovered and examined the details of, from A to Z, what we think happened in her particular case. We identified errors, and as a result, certain required actions were directed to fix those. One was the training of certain SHARP personnel. One was the termination of SHARP personnel. There were other actions taken. The forms that were used, for example, were out of date. All of that has been fixed. Subsequent to that, a DAIG investigation was conducted to ensure compliance with the requirements of the program, and that yielded a positive report back that things had been fixed at that location. And then, of course, sir, I'd offer that Army senior leadership was very concerned as well. They looked at this case very carefully and took appropriate action.
In the prior panel, I asked a question about our allies who have moved to a program similar to what's being proposed by Senator Gillibrand, or frameworks, and they were doing it, at least based on the information that I've read, to protect the rights of the accuser. There have been some who have said that the standard of evidence or proof, if you were to move this out of command, is a higher bar, and you could have a risk of fewer cases actually being brought forward. Do you all agree or disagree with that? Or General Lecce, we'll start with you.
Thank you, Mr. Chairman. You know, I have to state that in the current process, there are lawyers throughout the process, sir. So from really the inception, as we've been briefing, the victim's legal counsel is involved in the case, and then as it moves through, you know, we have prosecutors, specially trained prosecutors, special victims and investigation prosecutors, and a full team that deals with these cases, sir. Additionally, each General Court-Martial Convening Authority has a staff judge advocate assigned who provides advice. So, you know, regarding the entire chain of command, lawyers are involved providing advice, good, sound, and accurate advice on how to handle cases. You know, frankly, I think if you took the commanders out, then you strip the system of the bedrock, the mantle of command, sir, and that is the welfare of all the Marines for the Marine Corps, all the Marines under his or her command. That includes the victim and the accused and the unit itself, sir. So, you know, if you took the commander out, how would that affect prosecution rates? I couldn't say exactly, sir, but I don't think that you would see an improvement in the rates. You actually might see a decline, sir.
Anything to add down the line? And Dr. Van Winkle, of course.
Sir, Mr. Chairman, that was driven by a European court decision, and it was focused on accused rights, defendants' rights, which drove that decision or some of that pressure to remove the commanders from that process. We don't see any evidence that it's gotten better, sexual assault, and how we handle it across the board. In looking at those systems, we're hesitant to look at those systems because we don't tell other countries how to do things, but we're convinced things have not gotten better and probably have gotten worse with regard to attacking sex assault based on that unity of command and unity of effort and continuum issue that we see.
Admiral, anything to add?
I'll just add, it's very clear that probable cause has to exist for charges to be referred. And in the non-binding disposition guidance that was required by Military Justice Act of 2016, put out by the Secretary of Defense, it also requires consideration of whether admissible evidence will likely be sufficient to obtain and sustain a conviction in a trial by court-martial. So I think that standard is there, and I think in the Navy, just like in the Marine Corps and the other services, lawyers are there in the process, talking to and informing the commanders at every step.
What do you say to the and Dr. Van Winkle? I see you taking notes. So I want to come back to you and maybe you do clean up on some of the questions, or I should not clean up, but you know, like in batting. What about the pushback that says, yeah, I've got a lawyer, but it's not a trained lawyer? What's your response to that? I got a lawyer, but they're not somebody who's an expert in sexual assault. I mean, well, I don't know what your resources are and who's in the loop when you have legal advisors, but how would you all respond to that assertion? We'll start with General Petey.
Sir, with respect to the last 10 years in particular, we have devoted extraordinary attention to the development of expertise in the prosecution and defense as well of sexual assault. And so whether it's the prosecutor, the prosecution function, the defense function, and now the Special Victim Counsel, sir, superbly trained. I just attended and spoke to a course in our JAG school in Charlottesville, our Special Victim Counsel course. The training is just top-notch. So the level of training and experience that counsel for each of the components of our system is superb. They're well-trained. They're also well-exercised, sir. The number of cases that we have, as you know, is going up. The allegations are up, and that requires a level of robust energy that I think we would all admire. That doesn't mean we're not making mistakes, sir. That doesn't mean there's a learning curve. There is. It's very, very hard. These are the hardest cases to try and win and also to defend, sir.
Similar position among the others?
Yes, sir. Just in the military justice litigation track that I mentioned, we have 81 officers in there. That's about 10% of our Navy JAG Corps. 16 billets on the prosecution side, 14 on the defense side. We currently have 5 in Victims Legal Counsel. And so these are people who, through the course of their career, are spending the majority of their tours in military justice, in the courtroom or helping victims.
Is that somewhat unique to the Navy?
I believe that we're the only one with the track, but the other services can tell you how they try to develop similar capability.
Okay. General Rockwell?
Yes, sir. It is similar. If you look across the services, although we may not call it a litigation track, we have a military justice capability that includes significant litigation. When you look at it from an institutional capability across the services, and I think you need to look at it from a special victims prosecutor standpoint, which we have several of those who handle these complex cases, particularly sex assault. Equally, our defense counsel are getting very smart in these cases. Our victims counsel are phenomenal. Our victims counsel are driving change. A lot of times we say they're too young and inexperienced to help this effort. I think it's the other way around. They're actually young and know what they're doing, and they're telling us things that otherwise we wouldn't know about. The power of that program is phenomenal. When you bring all these pieces together, I think we all equally have an institutional capability that is as good as anyone's.
General Lecce.
Mr. Chairman, I have almost 70 LLM Master of Law trained judge advocates in criminal justice. They all have their advanced degree. They rest both on the trial and the defense side. In any complex litigation, sir, involving felony level, including all sexual assaults, these cases are handled by a complex trial team that it's made up of. It's a 4409 as the additional MOS. So that's an LLM-trained criminal prosecutor, a civilian, a GS-15 level attorney advisor that has a lot of experience and provides expert advice. Also, sir, we have a specially trained SVIP, as we call it, Special Victims and Investigative Prosecution investigator, a CID investigator also assigned to the team, along with an illegal administrative officer. That's for every case. Every case that is at this level, felony level case, gets this team assigned. So resource-wise, looking at my civilian counterparts, I think I outpace any of them. What we don't, and getting to Colonel Christensen's point, is what we don't have is a number of sets and reps, which may be a good thing because we don't have the level of sexual assault that's occurring out in the civilian world. But I will match my team against any team that you have out there in the civilian side, sir.
Dr. Van Winkle, in the prior panel, Callisto was mentioned as a tool that allows victims to possibly connect the dots. I think most of what I've read suggests that somebody who's guilty of sexual assault seldom does it only one time. Have we taken a look at this as a tool that we could use within DOD?
We have, and thanks for the question. Trying to get folks to come forward and report is our primary way of holding offenders appropriately accountable. So it's very critical to us to get more people to come forward and report, understanding it's a personal decision, and we certainly rely on the victim to make that decision themselves. One of the things we hear particularly from our academy students is the concern about coming forward on their own and concern about it being a label that they have to live with. And that's something we hear in colleges and universities too. And so the Callisto program aimed to do a number of things, both address repeat offenders, but also address that concern of being the voice of one. And so what we're doing in terms of this is in the summer we'll be implementing something we're calling the CATCH program, which aligns with what Callisto does. So it allows somebody to make a restricted report and then in their own time to provide us information about the offender, their name, biomarkings, tattoos, those types of things, as well as social media handles, any information that identifies the offender. That then gets locked, only accessible to the military criminal investigative organizations. If somebody else, even years later, identifies the same offender, the military criminal investigative organization is notified. They then notify those victims to let them know that somebody else identified their offender and would they be willing to come forward and make a report. So it again aligns with the goals of Callisto, and we're hoping that it will address some of the concerns that we hear.
Final question, and we may follow up, or committee staff will be following up, because obviously this is something we'll continue to focus on. Right now, when you're sitting down and you're talking with commanders about expectations, standard operating procedure for how a commander should deal with this, is there a consistent message that every line of service conveys, or is there an adjustment based on the branch? In other words, is this the whole of DOD, this is how we deal with it, this is what we expect of our commanders, or is that left to each of the services to determine how to do that?
I would have to defer to my colleagues for the specifics on that. I will say that we do often recognize that within this space, not all service members look the same. What resonates for a member of the Air Force doesn't always resonate for the Marine Corps. So we do allow for some of that unique culture, but I would...
Well, let me poison the well before you answer the question. I don't see any rational basis for any difference. Sexual assault is sexual assault. The expectation that you have the command should be the same, period, end of story. It'd be the same sort of response I'd get from somebody that says that housing's different for the Army than it is for the Marines when I'm dealing with this family housing situation. Now, one of the problems is we do have some adjustments and changes, and I think that's going to be the root cause of the issues we have there. This should be a consistent, if we want to create a pervasive culture, if we want to have a standard, if we want to have the same expectation of the commanders, I tend to be biased more towards keeping this with the command. I think that it has to start with the whole of DOD, because incidentally, this isn't limited to just people who work in the DOD who happen to have uniforms. Hold you all to a higher standard because of the jobs that you do. But I really think we need to look long and hard and say, for some reason, the way that I tell a commander in the Marines to deal with a sexual assault is different than I tell somebody in the Army. I don't see any rational basis for it. And if we want to perpetuate, we want to make pervasive a culture that's a consistent message in every case, we really ought to think about comparing notes and building on better or best practices. Final comments for any of you on that?
I think the linchpin of this decision, if you break down a process, is in the referral process. That's where you sit down with the commander and say, are you going to refer this to court-martial or not? The standardization is there under the rules of court-martial. Do you have probable cause to determine whether or not an offense has been committed that would take it to the next piece of this this process, which is the trial? We're more comfortable with that process, of course, the trial, because it's judge-driven and all the rules that you see at a trial come out then. But you're right, sir. That's where I think is the primary fundamental point.
I don't mind somebody taking the lead, but it's like you get to a best practice and build on a best practice versus going 4 different ways and creating 4 different cultures. The other thing I will tell you that Lieutenant Commander brought up in the prior panel, whatever person in the chain of command would have inappropriately shared information about her personal circumstances, I'm sure that is a violation somewhere along the lines, and we have to make sure that that is also a part of the culture. I mean, what a disgrace to have somebody do that. That is somebody whose file comes before me, better be thinking about a new line of work, because that's not the way to deal with these cases. Look, It was really impactful to see the housing. I was down at Fort Bragg on Friday, and it was amazing to me to see these young people apprehensive about reporting that they have mold growing on their walls, right? Now imagine somebody who's been a victim of sexual assault, the bar that raises to for them to actually come out and have trust and feel like they'll have the support of their command as they're going through it. I know not everybody who's accused is guilty. That's why we have a legal process that we have to go through and determine guilt or innocence. But all along the way, we need to show respect for all the parties. We need to keep their information in the utmost confidence, and there needs to be very clear accountability for anybody who's sharing this information along the way. Well, I want to thank you all for being here today. I tend to go last so that I can go over, and I appreciate you all indulging me on 2 or 3 times more time than I had, but this is only the beginning. We'll be asking you additional questions. We'll be asking you for suggestions on how we can improve things, and we'll also have the committee reach out. I want to see how some of our allies have done this and learn from their strengths, weaknesses, and their own implementation failures. But I tend to agree with the positions of the folks before us today, but we can get better. And I also believe that Senator Gillibrand brings a lot of expertise and a lot of ideas on things that can improve the process, regardless of whether or not we shift responsibility from the commands. Thank you all for being here. The meeting's adjourned.
In the middle.